the details and the experience and how to get the most of your applications. We are the largest immigration agency in Latin America. Proudly, we have more than 24 employees working in assisting people from Chile to Mexico. And of course, we have a lot of clients here in Australia. Um, our commitment is with your success. I think this is where we are very proud of. Um, we consider that getting the visa is not a matter of chance. It's not because you are lucky or you are not lucky. Getting the visa, obtaining residency in Australia is a process. And it's a process that is well done in such a way we get the visa. So we are quite oriented to have quality processes in place, assure that what you're doing is providing the evidence in the proper way so we get the visas. Well, we have more than 1,000 visas approved, and our success rate is more than the 98%. Talking about the now, why we're talking about this subject, the partner visa, it's important to mention that for the federal budget 2020-2021, the federal government allocated 74,000 places for in the family stream, which is a big improvement from the last allocation, which was barely 40,000. From this increase, 32,000 are partner visas. And in those partner visas, those type of partner visas has priority. The first one is priority for applicants who are already onshore. And secondly, there is a priority for those visas where the Australian sponsor is located in regional Australia. So this is the context. This is why I consider that applying for partner visa is a very extreme good opportunity to do it now. Nevertheless, there is some changes in the visa and in the requirements that will be the more important part of the subject. Now I pass the word to Mirella, that she will talk a little bit about which is entitled the in the partner visas.
Thank you. Thank you very much, Juan. Well, my name is Mirela Fernandez, and I'm one of the registered migration agents of RC Australia. And today we would like to explain how to apply for a partner visa. This is a very particular process because when a person applies for a partner visa, he or she will apply for a temporary visa and for a permanent visa at the same time. So this is a very particular situation. It is a two-stage process. As you can see here in the slide, you will find that the first one, I will explain, is the 820, 801. Those are the temporary and the permanent visa that must be applied from within Australia. So if you are in Australia, these ones are the ones that you will apply for. And the other two are the 309 and the 100 visas. These ones must be applied when the applicant is outside Australia. So in these cases, the first two, the 820 and the 309, which are the temporary visas, are valid for 2 years from the date of application. This means that the person will be granted, since the moment they apply, the relationship will be assessed for 2 years before they can go through the next step, which is the permanent stage of the visa, the partner visa application. There are some exemptions to this 2 years rule. And for example, if you apply and you are in a long-term relationship for at least 3 years, well, you don't have to wait for these 2 years, and the department, if they consider that they have enough evidence, will go directly to the permanent stage of the partner visa. Or if the applicant, the sponsor and the applicant have a child of at least 2 years. So those are two situations where this 2 years period can be waived. But in general, you apply for a visa, and after 2 years, the relationship will be assessed again. And if the relationship is genuine and ongoing, it will go through the permanent stage. This is important to understand. What does it mean, a partner, for the Australian legislation? The first option is two persons that are in a married relationship. This marriage has to be a legal marriage under the Australian law. In Australia, a married relationship could be for persons of opposite sex or the same sex. That's the first option. The second option is for two persons that are in a de facto relationship of at least 12 months. And there is an exception to these 12 months. And sometimes people can apply for a partner visa with de facto relationship, maybe shorter than 12 months. But the requirement is that the relationship is registered under state or territory law. We will talk a little bit more about this later. In every circumstance, so the three that I already mentioned, we always need to provide evidence of a mutual commitment to a shared life to exclusion of all others. So the relationship has to be exclusive between the sponsor and the applicant. The relationship has to be genuine and continuing. And the applicant and the sponsor, they have to live together, or at least do not have to live separately and apart on a permanent basis. Of course, if you live together, for example, due job reasons, it's understandable and it can be explained, but it doesn't have to be on a permanent basis. Um, Sorry, no, that's fine. And this is a different type of visa. I explained when you apply for a partner visa, but this is a different visa, which is the Prospective Marriage 300. And this visa is when the person wants to marry an Australian citizen or a permanent resident. This visa must be applied from outside Australia. This visa allows the applicant to travel to Australia and remain in Australia for a period of 9 months from the date of grant. While the visa is in effect, it is a condition that the applicant must marry and lodge an 820 801 visa while onshore, or meaning in Australia. So the person will have 9 months to do that, travel to Australia and get married to the sponsor. This visa cannot be extended or renewed, and the marriage must have taken place within those 9 months of the grant. Otherwise, will be in breach of their visa condition. There are some sponsorship limitations in the law. For example, the first question is, how many partners can a sponsor nominate to come to Australia? And the answer is two, no more than two in a lifetime. So if the sponsor has previously sponsored a partner, 5 years must pass from the date of the first application. So we have to wait for 5 years until a new application can be decided. The first application has to be decided. For example, if you apply for a visa and that visa was withdrawn, well, in that case, the 5-year rule, it doesn't apply. But in the case that the first visa was applied and it was granted, well, to sponsor another partner, we have to wait for 5 years. There is a situation, for example, the sponsor has already sponsored two different people and those visas were granted. That person won't be able to sponsor someone else unless there is a waiver. So if the sponsor doesn't get a waiver, won't be able to apply a different person. Another circumstance is, for example, a person who has been sponsored for a partner visa now wants to sponsor someone else because the first relationship was broken and wants to sponsor someone else. In this case, this person has to wait 5 years again from the date that their application was lodged to be able to sponsor someone else. As I said, there were some waiver provisions, and usually are based on compelling circumstances. For example, if you want to sponsor someone else before these 5 years and there is a dependent child of the relationship, well, it might be considered. Of the previous partner has died, or the new and current relationship is a long-term one. So there are some situations where these 5 years can be waived. We will also like to explain these matters that we need to provide evidence, because when the department assess the relationship, they will ask us to provide evidence of four, let's say, pillars of the partner visa application, which are the financial aspects. This is the first one. How can we provide evidence of the financial aspects of the relationship? These are examples. For example, joint ownership of real estate or other major assets, um, joint liabilities, pooling of finances resources, mutual legal obligations, sharing of household expenses. Um, we also need to provide evidence about the nature of the household, and we will explain the joint responsibility for care and support of children if the couple has children, living arrangement, sharing responsibility of the housework. These are the other two aspects, the social aspects, like representing to others as a married or de facto couple, opinion of friends and relatives about the relationship, plans and undertaking of social activities. Mutual commitment between the applicant and the sponsor, and then we will explain the duration of the relationship, the time living together, the degree of mutual companionship and emotional support. And of course, if the relationship is a long-term one, we will explain that as well. Um, Now, Juan will explain the announcement that was made when the budget was presented for this financial year. We have some new requirements that will commence next year, approximately by the middle of the year or late 2021.
Thank you, Maria. Well, this is the funny part. Uh, Usually, the partner visa is, for, until now, just a visa. So when you get decided, you just load the visa. So the first, so we don't need that the sponsor be approved, and this is one of the two major changes. Meaning, we have to get from maybe November, June onwards, get the sponsor approved. So once the sponsor is approved as a suitable partner for the applicant, the partner visa can be launched. So the sponsorship and the application is split into two separate processes. The point being is the requirements for approving the sponsors seems to be not too hard. It's basically polycheck, proving that the person is a suitable sponsor in terms of the ability to, well, sponsorship, as Mirella just said, no more than two sponsorships, keen to comply with the obligation as a sponsor, but nothing else. There is not an income test. There is not residency test. Is really nothing else but to check the character test. Be aware that this new scheme where the visa is split into two come as part of the domestic violence rules, where they are trying to avoid that the partner visa become a situation where the domestic violence can occur. So one of the things we must consider is this one, that we must get the sponsors approved first, and just then we can launch the partner visa. This is the first change and it's coming. The second one is that both the applicant and the sponsor, if the sponsor is not Australian citizen, both must to evidence that they can speak English, just as they sound. Before that, the partner visa doesn't have any English requirements. From then on, English will be necessary to be assessed, but be aware that is just in the last and second part of the visa, not for the temporary part, but for proceed to the permanent visa. So once you lodge your visa, you get into a temporary period. At the end of the temporary period, which is about 2 years, you will be eligible for the permanent visa, and then you must to prove that you have functional English. In a sec, Mirela will tell you how that works.
Thank you. So I will try to explain. Can you see my mouse? Is that correct? Thank you, Nicolas. So um, this is our current timeline for a partner visa. For example, this is just an example. We have an applicant who is on a student visa or a temporary skill shortage visa or on a tourist visa, whatever. The person is on a substantive visa. And let's say at this point, the person makes a valid partner visa application. The person will be granted a bridging visa A, which will remain inactive until the substantive visa expires. When this occurs, the bridging visa A will become active. Um, this is a situation that we constantly find in consultation. For example, someone who is on a student visa asks us, okay, I want to apply for a partner visa. Can I stop studying? It's very, very frequent. And our advice is if you stop studying, your student visa might be canceled. And if your student visa is canceled, this will have consequences on your bridging visa because in this situation, you have a bridging visa A because at the moment you applied, you already had a substantive visa in force. But if this visa for any reason is cancelled, this bridging visa A will change and it will affect your work rights. So we always give the advice to our clients as far as they can, of course, keep with your studies until your visa finishes, comply with the conditions of your visa until your visa finishes, and then you can be in this situation with a bridging visa A active, which will have full right works. Um, as you can see, the 2 years period that the department will assess your relationship until we can pass to the permanent stage is counted from the time of application. So, because this visa can take sometimes a year or a year and a half to be granted, sometimes actually you will spend maybe 6 months or approximately 6 months on a temporary partner visa. And once you have 2 years since the time of application, you can provide new evidence that the relationship is still ongoing, and then the permanent visa can be granted. So this is the current situation, but let's take a look at how it will be in the future. Um, because in the future it will be necessary to have a sponsor application approved, you won't be able to have a bridging visa until the sponsor is approved. So let's come back for a moment to our current timeline. Let's say you apply for a partner visa here at the very end of your current visa. This is now possible. But let's go back to the future timeline. You won't be able to do that because you won't be granted a bridging visa A until the sponsorship application is approved, because this application won't grant a bridging visa A. So this is something to consider. It won't be like a last alternative. My visa is about to expire. I will apply for a partner visa. That won't be possible in the future. We don't know how long it will take to a sponsor to be approved. It will be a couple of weeks, it will be a couple of months. It will depend on the evidence that we need to provide. For example, if we need to provide character tests from overseas, it could take longer. So we really don't exactly know how long will that take. Okay. And then we would like to talk about some difficult cases. And this is all coming from our experience. So what happens, for example, when a person is still married to another person? Of course, it's very unusual, but it might happen. As I said before, one of the requirements for the partner visa to be granted is that the couple has a mutual commitment to a shared life with exclusion of all others. The regulations specifically require that the couple don't have any other concurrent spouse or de facto partner, meaning that the relationship between the visa applicant and the de facto partner or the husband or wife must be mutually exclusive. But again, what happens if one of them is still married to someone else? Well, generally, you need to provide evidence of divorce or annulment of the marriage as a proof that the marriage has ended. But sometimes it can happen that because of the laws of the country in which the person lived, that was not possible. It was not possible to obtain a divorce or an annulment of a marriage. So in those cases, the case officer of the department has some freedom, but the case officer has to be satisfied that the couple has made a reasonable effort to obtain evidence of a divorce or annulment of a marriage, but has been unable to get it. So it's open to the delegate of the department to assess the evidence provided to demonstrate that the couple is in a mutually exclusive relationship. So of course, again, it's not the ideal situation, but it might occur, and we can follow this guidance.
Other cases that happen is when the applicant doesn't have these. For any reason, his or her visa has expired or has been refused. And when one person get the visa refused, usually must to apply for before the tribunals, the administrative appeal tribunal, in order to get this decision reviewed by the tribunal. But in the meanwhile, is subject to a ban to apply for another visa, with the exception of the partner visa. So in those cases where the applicant either doesn't have a visa or has a visa refuse, is you are able to apply for a partner visa. This is okay. This is one of the last resort options for people who doesn't have visa here, which is fine. Nevertheless, you must to be aware that you are in breach of one situation called condition 3, schedule 3, which means that you must to have special circumstances than affect an Australian citizen in order to get this situation waived. So when we have one client who doesn't have a visa, has a visa refuse, and apply to a partner visa, it's important that it's compulsory that we can provide evidence that the application of this visa will benefit in a compassionate way the Australian or permanent resident partner. This Schedule 3 is maybe one of the most important waivers we have to manage and it's very close to the application. So the partner visa used to be a very lengthy process. We lost your visa and the visa can wait 1 year, maybe more, to get assessed by the department. Not in the case of Schedule 3. In the case of the Schedule 3, in the following 28 days, sometimes before that, you get a request for information from the department asking you to demonstrate that this condition must to be waived. So be aware that if you are applying for a partner visa without a visa or from a visa refuse, you must to have evidence that there is compassionate circumstances in benefit of an Australian citizen to do that.
Thank you. Another difficult case is, for example, this is very common, applying when the couple has less than 12 months of a de facto relationship. This is the case when the couple is applying on shore for a 820, 801. The requirement, as we said before, is that the couple has been in a facto relationship for 12 months. And the exception is when the de facto relationship is a relationship that has been registered under a law of a state or territory. So we can apply before the 12 months. But in these cases, it's crucial to be very careful providing evidence about the genuineness of the relationship, about the way the relationship developed. It has to be explained the degree of commitment to each other. This can be particularly difficult when there is a very short period of time between the parties first meeting each other and deciding to commit to a shared life together. But if the couple have been for less than 12 months, but we have all the evidence we need to provide, is not a big issue. As I said, what concerns me a bit is when the period is really too short and we don't have the evidence. And the evidence is all that we already mentioned before. So now we are going to talk about family violence provisions.
Yes. Unfortunately, in family and also in between the visas, domestic violence happens, and the migration law includes some provisions to avoid, or in other way to say, to protect the person who's a victim of the domestic violence in such a way that one person is a victim of domestic violence, he will obtain the permanent residency without a stay in the abusive relationship. The idea is that the domestic violence provision are one way to protect the people who are victims of domestic violence, and understanding by domestic violence situation like assault, stalking, comments that are derogatory, if they are attacking the property or attacking any person who anything that the applicant holds dear. But is more importantly the level to prove that there is the crime of the domestic violence is very demanding. But for migration purposes, is very low. The bar is very low because for migration purposes, is understood that domestic violence is that causes the alleged victim to reasonably fear for or be reasonably apprehensive for about or her well-being or safety. I would like to highlight the point that is about how the person feels. Maybe it's just the feeling. It's not necessary to provide evidence on some specific facts. When we represent clients in cases of domestic violence, always is necessary to provide a consultation with a psychiatrist or a psychologist or or a woman counselor, and they will say, yes, that's true. The behavior of the perpetrator is is in such a way that cause fear. Maybe never hit her, never make something criminal against them, but she was in fear, and the visa get approved. This is something that in somehow is very important for all the applicants to know, but they don't have to stay in an abusive relationship.
Thank you. So now we would like to give you some tips about how to make a successful visa application or how to be careful with some issues that we have identified as a bit dangerous. So we would like to explain some of those. The first one is be careful with social media. And this is because partner visas can be very intrusive. And if the department has doubts about the genuineness of the relationship, you need to know that they will seek information in any available means at its disposal. So if they have doubts about, for example, when the relationship has begun, or if you are indeed a couple, could be anything, it's very likely that they will look at their social media networks to learn about the situation. So you have to be very careful with what is published. So there are no inconsistencies that could jeopardize your application. This is, it seems silly, but it's very important.
Yeah. Other point is the use of the joint bank account. It's very common to say, that, okay, well, definitely the partner visa is going very well. We already opened a joint account, so we are on the safe. We are married. We can proceed for the to launch the partner visa, and the partner visa get approved. Yes and no. Be careful because of that. Because when you show that you have a joint account, you must to provide all the statements of the joint account, and the department will check all the income and the expenditure from this joint account, and even income and expenditure from the joint account must to match with the normal development of a family, meaning rent, groceries, bills, facilities, etc. from a family must to come from the joint account. Both salaries, income from both parties must to go to the joint account. Otherwise, the joint account will act against the application. So be careful when you decide to show that your financial agreement is to use a joint account. Be careful. Be aware that you must to prove in the statements that all the movements reveal the proper movement of a partnership or a marriage.
Another one is consistency with previous visa applications. And this is something that we see very, very often. For example, couples that register the relationship and declare that they have begun to live together earlier than when they actually did. And could be very serious, for example, if in a previous visa application, let's say a student visa or a work visa, whatever visa, and the applicant has declared as single, and now they are saying that they are in a partner relationship and those dates are not consistent. That kind of inconsistency uh, that were declared to the immigration department can put the application at risk. So you need to be very careful and consistent with your previous visa applications.
By the same token, be aware that the information you provide to other government bodies, such public housing, the ATO, any other entity, is also related with your social status. For instance, the people who the Australian residents or citizens who are in a relationship must to declare if they have a partner. If they don't declare they have a partner, they are, it is assumed they are still single. So that's why if a person who's in getting benefit from Centrelink in the Public Housing Commission, for instance, or otherwise, and don't declare that in a relationship, uh, is acting against the possibilities of getting the visa approved, as well both the applicant and the sponsor. When you lodge your tax return, there is a question about how long have you been in a relationship during the financial year. If part of your financial year, part of the financial year is covered, the time in the relationship must to be there too. So it's also a point to check.
Mhm. Beneficiary of superannuation. This is just another example of an element that can be very powerful when it comes to providing that a relationship is genuine. If the applicant and sponsor have each other as beneficiaries of the superannuation, it's a great evidence. But of course, it will depend on when they do it. For example, if they do it having received a request from the department to provide more evidence about the relationship, well, it's a bit late because it probably will not have the same weight that it would have done in advance. But if you do this in advance and you apply with this as an evidence, it's a great evidence of the genuineness of the relationship.
And lastly, another tip is anybody must to mention a next of kin at work, at the school, at university. So, and which is customary is you put your partner. So one of the things that move and then show evidence that the relationship is genuine is that you put your partner as a next of kin, the person to be called in case of an accident or in case of something happened to you. Uh, be aware that those tips could be seen like a little too much, but be aware that because of the partner visa is in some regards one easier way to get the permanent residency in Australia in comparison with the point tested visas or in comparison with the investment visas, there is a higher level or scrutiny from part of the government. Be aware there is a lot of counterfeit visas, people who make business of these visas. So the department is also um, being more stringent in the analysis of these visas. So, if you like a good visa, you must to provide all the evidence because this visa is not about your good faith. It's about the evidence you provided. This is our more important recommendation is the more evidence, the more solid, the more robust your visa. Now, Nicholas.
Well, that was fantastic, and I have received few questions in the messenger, and actually that's the time for the Q&A. If you have any questions, please ask them now. The first one is for Juan. It says that my partner is still processing his divorce from his previous marriage. Can he sponsor me?
Well, developing the idea that Mirelas, I will let you this question to you.
Okay. So the person says the partner is still processing his divorce, and I couldn't hear the last part. Sorry, Nicolas.
Yes, and is asking if, because he's still processing his divorce with his previous marriage, can he sponsor me? Can he actually be my sponsor?
So I would say that it's necessary to provide evidence that the previous relationship has ended and that you are on a mutual exclusive relationship with the applicant. And the onus is on the applicant. When I say the onus is who needs to provide the evidence, in this case is the sponsor and the applicant. So you need to explain everything. Usually, if it's just a matter of time, I'm sure you will be able to provide the divorce or the annulment of the marriage before your visa is decided. So it shouldn't be an issue. But if for some reason you don't have that at the time of application, well, that's something that we need to study in more detail. But if you ask my advice, if you don't have any reason for not having the divorce, I would wait until you have the divorce and then apply. And I'm not sure if you would like to add something else about that.
Well, yes, maybe Mirela, thank you. One of the things you must to keep in mind that this is a requirement at the time of the decision. So if the person is at the land going in the process of the divorce, still doesn't have the decree nisi, which is the final decree for the divorce, he still can apply for the partner visa because the partner visa takes time to get approved. So we can play with times. So we can launch the visa, wait until divorce get approved, and then the visa will be the partner visa will be approved. So it's a matter of timing, but definitely must to be divorced to get married again. Otherwise, will be bigamy, which is a crime.
Yes, and also to provide evidence at time of application that the relationship with the spouse has ended. That's very important.
It's very important.
The question regarding the English requirement. As a student, I finished an advanced diploma. Can I use this advanced diploma to prove that I speak English?
I'll answer this if you're okay. So if you, the question is, have you studied in Australia? Because it depends. If you studied a diploma outside of Australia in English, you need to provide evidence of 2 years of study. But if the studies are in Australia, 1 year of full-time study will be okay to demonstrate that you have functional English, which is the requirement for the partner visa.
Well, let's see. It says, well, this is the answer. There is, well, that person give us the answer. There is a question here that it says that I was in a previous relationship as a de facto. That relationship finished, and I didn't cancel the de facto on time to the lack of knowledge. And after I start my current relationship, which is now registered, I now had a new relationship. But is there any evidence that you can give me about mentioning on the statement letter? If I understand that question, that person never canceled that previous relationship. Now is currently in a new relationship. What should I do? Because there is an inconsistency there. There is a statement she needs to go and write a statement and say, look, I didn't know that, or what is the best thing that she can do?
Well, there is a procedure in most of the states that is a revocation of the relationship. And he procedure must to be completed. So he must to go to the place, usually the birth, death, and marriage registry, and revoke the relationship. I will recommend to do it explaining that he's revoking a relationship that ended long time ago. So try to backdate the revocation the most to the real date. But definitely the right way to do is through a revocation.
Okay. There's few other questions coming. This says, my partner has a police record. Will that affect my visa if he's the sponsor?
It might be. It will depend on what kind of record the partner has. And usually when the record is if the person was in prison for 12 months or something like that, yes, that could be an issue, but we should assess that in case by case. Yes.
All right. And what happened if there is another question and asking about the very first steps? If my current visa is going to expire at the late 2021, what should I do now? What documents do I need to prepare if I want to go and lodge a partner visa? What are all these first steps?
Well, we usually recommend to have a consultation with a migration agent, with us, with somebody else. But the first consultation we will serve you to have an initial assessment. As you can see, the partner visa has basically three big important pillars: the applicant, the sponsor, the relationship, and now the timing. So I will recommend that the first step is to do the planning, because based on that you will maybe keep in mind that you need some papers that are overseas. For instance, your divorce was not translated or was not registered. So before starting with something, you must to get this information, or you will need some documents from your child, or you need a permit from your ex-partner. There is too many points that we have to see, and the only moment to identify those points is in the initial assessment. Sometimes we spend months and months gathering documentation before we can lodge the visa.
Juan and Mirella, there is a really important question that I would like to ask you both, and it's about prospective marriage. There is a question here that there is the situation you need to get divorced, and while he's doing this process of the divorce, can he prepare a prospective marriage visa so his girlfriend can come into Australia as soon as possible? What is this processing now that we're living in this pandemic?
I'll answer the pandemic part first. Right now, the only persons that can come to Australia because the borders are closed are the partners of Australian citizens or Australian permanent residents. And they are the members of their family unit. Unfortunately, a fiancé is not a member of a family unit, and they are not allowed to be granted a permit to enter Australia. We know there have been exemptions based on compelling reasons, but there have been very, very, very few because, as a general rule, fiancés are not persons permitted to enter Australia. So I guess we need to wait until see what happens with the pandemic and the borders and all that. Mm-hmm.
And what will happen? That person needs to, as soon as possible, proceed with the divorce, and he's asking, should I? So until you answer, should he need to wait then, because it won't be possible apply for a prospective marriage?
Well, you can apply, but because you won't be able to enter Australia, the 9th month will pass, and you won't be able to enter. So the department, what it's doing is they are reimbursing the visa application charges to the applicants because it's a very expensive visa. But right now, they are not able to enter Australia. And regarding the question about the divorce of the partner the fiancé, sorry, to be able to marry someone else needs to be free to marriage. So he needs to get a divorce first if he wants to marry his or her fiancé. So, and the 300 visa, you only have 9 months to come to Australia and to marry the Australian or the permanent resident. So it's a very short period of time if you think about it. What do you think, Juan?
I'm with you. Sometimes maybe the best way is to apply for the partner visa, and if you see that the border is still closed, get married, because there is a provision that allow to convert partner fiancé visas into partner visas without extra cost. So maybe marriage by proxy you can use to convert the fiancé visa in a partner visa, so you can come if definitely the borders is still closed and you don't get an exception, as Mirela said. You can use the conversion to a partner visa in order to get to Australia.
Okay, well, that's fantastic. I'm grateful to hear you tonight. That's all for tonight. Tomorrow we will have the Spanish version for all of you, or maybe you partners that are really keen to take this webinar in Spanish. And I know that there is few other questions that haven't been resolved. So please, we are here, more happy to hear you. These visas, as you hear, are quite difficult. It seems easier, but they're not. It needs to be analyzed case by case. We will also love to invite you for the next webinars. We are going to talk with Projects RH and Rebel Gold Coast about investment visas and the new Global Talent Program visas next week. If you have any questions, or if you would like to discuss a little bit further those questions that you asked today, you could call us or send us an email, and we will be more than happy to talk with you, analyze this case by case. Thanks a lot, Juan and Mirela.
Pleasure.
Thank you, Nicolas, and thank you to all the attendees. It was a pleasure.
Okay. Okay.
Have a good night.